I'm very grateful, Madam Deputy Speaker. It's a pleasure to follow the wise words of the Honourable Member for Hartlepool. It was a pleasure to serve with him on this committee. And may I associate myself with the remarks both he and the Right Honourable Member for Birkenhead made about our hard-working committee clerks through this process. When the news of BHS broke, I felt bad about the loss of a high street icon, desperate for the employees affected, including those of my Horsham constituency, and very concerned about the pensioners. However, I have a confession to make to the House. My gut reaction was that a committee inquiry would be raking over the ashes of a sad event with little to be gained. I was initially not convinced an inquiry would be productive, but I was persuaded to take part. I'm glad I did, and I'm glad that this inquiry has taken place, for I believe we're in a position to lay concerns before this House. The largest concerns for me are not particularly about the individual trading circumstances leading to the demise of BHS, though it seems, as the honourable gentleman preceding me said, that there's little magic around the revitalisation of BHS's margins in the early years of its ownership by Sir Philip Green. Dividend payments, generous as they were, exceeding profits as they did, may or may not have undermined the BHS through underinvestment. This would be hard to prove, but it's a perfectly sensible question to pose. Directors cannot, I give way to my honourable gentleman.
I'm very grateful for the honourable member for giving way. Should we not, though, be raising questions that if any company is paying out dividends that are in excess of its free cash flow, then that should be raising alarm bells, and perhaps there needs to be a test that companies should be meeting if they're behaving in such a way.
Hear, hear. Hear, hear.
The honourable gentleman, as so often, reads my mind. He has to be a little patient, and I will come on to a very, very similar point at a later point in this speech. But what I would say in terms of that period of time when these very generous dividends were being paid out, directors can't be expected to have the gift of prophecy, but they must be expected to understand the fundamental trends driving the underlying profitability of their business and its sustainability. I'm far from convinced that was the case in this situation. The most serious questions, as raised by the Honourable Gentleman from Hartlepool and intervention by the Honourable Gentleman from Torvine, are about the corporate governance of large private companies with millions of employees and pensioners. Now, unlike my feisty friend, the Honourable Member for Bedford, I intended to come here today without making any reference to the individuals concerned directly in the sad demise of BHS. I wanted to focus on the more general lessons to be learned. I'm afraid I've been brought back to the particular circumstances of BHS, having read last night the joint legal opinion produced for Tavita Investments Limited by Learned Counsel. The two lead QCs, as the Right Honourable Gentleman referenced, make a point of saying that they're friends of the chairman of TIL, and I hope the report, which is considerably longer than the joint report it analyses, wasn't unduly costly. The report basically starts by saying, let's pretend this was not a parliamentary inquiry, but some other kind of inquiry. Would that type of inquiry be set aside by the courts? Having set up an irrelevant question, the opinion produces an irrelevant answer. I will happily give way.
Would you agree with me that it seems somewhat ironic that Sir Philip is complaining bitterly about an outcome with which he doesn't agree, and is able to pay handsomely for 81 pages of two eminent QC's reports, a tactic that unfortunately the pensioners and employees aren't able to resort to, I imagine.
It depends, I suppose, on the quality of the report. Frankly, having read the report, find it a whole series of straw men that have been set up for demolition. It doesn't help this chamber, doesn't help the pensioners, doesn't help anyone to understand, in my view, the circumstances around the demise of BHS. But to put the minds at rest of the Learned Counsel, the committee did not object to a dowry being provided on the sale of BHS. It certainly didn't question its legality. We questioned, though, the sufficiency of the cash and the choice of partner in the circumstances that BHS faced. Nor did we question the concept of a company being sold for £1. Clearly this is a matter for TIL2, the selling company. TIL2 having received £1, it is unfortunate that TIL2, ultimately controlled by Lady Green, is still paying back to Lady Green the £200 million consideration for its acquisition of BHS in 2009, this consideration being satisfied by £200 million of loan stock being provided to 3 overseas companies controlled by Lady Green with a coupon of 8%. It would take a much longer debate, and I'm very mindful that others wish to participate. It would take a longer debate to draw out all the straw men contained in Learned Counsel's joint opinion, but several others are produced in the context of corporate governance. A rare point on which the Joint Committee's perspective seems to be shared by Learned Counsel is on the, in our view, lax governance around the sale, so eloquently described by my honourable friend, the member for Bedford. However, Learned Counsel state that this is an irrelevance. It's an irrelevance. Because in any event, the shareholders in TIL could provide a direction, and therefore the directors were in no position to prevent the sale of BHS to any party. Well, Madam Deputy Speaker, this may be legally true, but to this House it should raise questions. TIL is owned 88% by Tabita Limited, a company registered in Jersey, and 12% by 6 minority shareholders. We're informed that the ultimate beneficial owner of the Jersey company is Lady Green. Learned Counsel inform us that under the articles, Lady Green, acting with any one of the other minority shareholders, could have directed the sale of BHS at any time and on any terms. Now, the right to own and to dispose of property under English law is absolutely fundamental, and Parliament will be wise to tread very softly. But I'm concerned in this context about checks and balances, not only on the sale but more generally. What is the value of a Section 172 provision telling directors to have regard to other stakeholders in these circumstances? What is the role and purpose of non-executive directors, especially when the 88% shareholder is not present around the boardroom table? It is not, to my mind, appropriate for directors serving private companies to decide that they can take a different approach to what is good corporate governance purely because they can ultimately be directed. It makes it more important, especially on major or related transactions and on honouring commitments to pensioners, that they bend over backwards to adhere to strong and demanding codes and are prepared to call out owners if they feel actions are being taken that do not take sufficient regard to other stakeholders. Madam Deputy Speaker, there are thousands of very successful medium and large private companies employing millions. For those millions, I think the ownership should be transparent, as should good corporate governance. There are other issues from which I've been sidetracked, I fear, by the legal opinion, but which this House, I think, should give consideration. And if I may, these include the application of corporate governance codes, as referred to by the honourable gentleman from Hartlepool, to be applied not only to listed companies, but to those owned privately. On related party transactions, the importance of independent valuations or independent opinions when these exceed de minimis levels. The utility of the with regard statement in section 172 and how directors can be expected to take regard while owing responsibility elsewhere. The appropriateness of dividend payments above certain thresholds, particularly if the pension scheme is in serious deficit, as I was challenged by the honourable gentleman from the Scottish National Party. A requirement for courts to be cognisant of pension deficits as well as creditors when considering applications for corporate restructurings and capital reductions. In private M&A, where pension problems may be less transparent than in the listed market, consideration should be given to compulsory engagement with the pensions regulator and with trustees. For both directors and advisors engaged in sale processes in respect of a company in which the pensions regulator has already expressed concern, if a sale is not pre-cleared by the pensions regulator, all parties should be very aware of the actuality of the counterparty to whom they are selling. English law requires no due diligence to be done on the buyer, nor to my mind should it, but common sense suggests a certain wariness to be wise. There are lessons, in conclusion, there are lessons to be learned from this sad story. But above all, we'll all be focused on the loss of a well-loved icon, the employees who are redundant, the pensioners who are rightly worried, but whose plight may yet be mitigated by Sir Philip. This would indeed be an honourable and very welcome act. I understand from the radio this morning that he is, not for the first time, planning to meet the regulators in the next few days. Time will tell whether pensioners have been waiting for a result or have been made to endure a particularly poorly directed waiting for Godot.